Let's get started if we
Think
could.
about this.
Good afternoon, everyone. This is Vice Chair Michelle Larkin. I'd like to call to order this meeting of the Minnesota Sentencing Guidelines Commission on Thursday, July 25th, 2024. Our chair, Mitchell, is unexpectedly and unavoidably not able to be with us in person this afternoon, so she's appearing remotely. I'm going to do my best to fill in for her capable self in her absence. We have a lot to tackle at this meeting. I think we discussed at the last meeting that there is a Supreme Court investiture ceremony this afternoon, so we want to try to wrap up all of our business sometime between 2 and 3. I know probably the judges and I have a hard stop at 3, so if we're ending up going past that, Chair Mitchell has agreed that she will step in and handle the rest of the meeting. In addition to the scheduling note, I would note that we do have a new member joining us for the first time today. That is Amarthini Keith, and she is going to be our victim representative. I believe she is appearing remotely this afternoon. I'm not sure if she's signed on yet. But with that, we should ask Nate to do the roll call for us, and we'll get started.
Thank you, Madam Chair. Roll call, Vice Chair Larkin.
Present.
Larkin present. Commissioner Crutchfield.
Here.
Crutchfield present. Commissioner Fraze.
Here.
Fraze present. Commissioner Keefe. Keefe absent at this time. Commissioner Knudsen.
Here.
Knudsen present. Commissioner Ladd.
Present.
Ladd present. Commissioner Middlebrook.
Present.
Middlebrook present. Commissioner Moore.
Present.
Moore present. Commissioner Moran.
Present.
Moran present. Commissioner Mueller.
Present.
Mueller present. Commissioner Reeves.
Present.
Reeves present. Commissioner Saxena.
Present.
Saxena present. Chair Mitchell.
Present.
Mitchell present. Madam Chair, there are 12 members present, 1 member absent.
Excellent. We'll move on to the next item on the agenda, which is approval of the draft meeting agenda. Is there a motion to approve the agenda? All right, I see Commissioner Reeves moving and seconded by Commissioner Middlebrook. Do we take the vote?
To the Reeves motion to adopt the agenda, Vice Chair Larkin.
Yes.
Larkin, yes. Crutchfield.
Aye.
Crutchfield, yes. Fraze.
Yes.
Fraze, yes. Keefe. Keefe absent. Knudsen.
Yes.
Knudsen, yes. Ladd.
Yes.
Ladd, yes. Middlebrook.
Yes.
Middlebrook, yes. Moore.
Yes.
Moore, yes. Moran.
Yes.
Moran, yes. Mueller.
Yes.
Mueller, yes. Reeves.
Yes.
Reeves, yes. Saxena.
Yes.
Saxena, yes. Mitchell. Mitchell, yes. Madam Chair, there are 12 votes in favor, no votes opposed.
All right, the agenda is then approved. We'll next move on to approval of the draft meeting minutes from our June 26th meeting, or June 6th meeting, pardon me. Is there a motion to approve the minutes?
So moved.
Second.
All right. Would you take the vote?
Sure. I just missed who made the motion.
Commissioner Mueller moved.
Okay.
Commissioner Knudsen second.
Thank you, Madam Chair. To the Mueller motion to approve the draft meeting minutes of June 6, 2024. Larkin.
Yes.
Larkin, yes. Crutchfield.
Yes.
Crutchfield, yes. Fraze.
Yes.
Fraze, yes. Keefe. Keefe absent. Knudsen.
Yes.
Knudsen, yes. Ladd.
Yes.
Ladd, yes. Middlebrook.
Yes.
Middlebrook, yes. Moore.
Yes.
Moore, yes. Moran.
Yes.
Moran, yes. Mueller.
Yes.
Mueller, yes. Reeves.
Yes.
Reeves, yes. Saxena.
Yes.
Saxena, yes. Mitchell.
Yes.
Mitchell, yes. Madam Chair, there are 12 votes in favor, no votes opposed.
Excellent. The draft meeting minutes are approved. We'll next have a review of the public hearing record from our hearing last week.
Thank you, Madam Chair. For the record, on Monday, June 17th, 2024, the notice of public hearing was published in the State Register, Volume 48, Number 51, and the contents of the proposed modifications were posted on the Commission's website. The same day, an email notice of public hearing was sent to persons who have signed up on the Commission's website to receive such informational emails. No one was notified by United States Mail because there are no longer members of the public on the United States mailing list. Pursuant to the public hearing notice, the public hearing was held on July 18th, 2024 in the Minnesota Senate Building, room 1100, and by telephone and or electronically. No members of the public wished to or did testify. After the public hearing, the record remained open for 5 calendar days through July 23rd to accept written comments. From the beginning of the public hearing notice period through the end of the public comment period, the Commission received 1 written comment regarding the subject of the public hearing. The complete public hearing record, including a list of those who spoke at the hearing, which was none, a link to the video and audio of the hearing, and copies of the written comment, was provided to all Commission members on July 18th and 19th, 2024, was posted in its entirety on the Commission's website, and is included in today's meeting materials. Madam Chair, the Commission appears to have substantially complied with all public notice and hearing requirements to permit it to take final action on the proposed modifications today. Thank you.
I note that we received, as I understand it, only 1 comment, and it concerned the offense of the straw man transfer. It had to do with the possibility of expanding the law to include the purchase and transfer of ammunition, which is noted, and we thank the commenter for sharing that with us, but do note that, of course, that is something that the legislature would have to consider. It's beyond what we can do in terms of ranking what the crimes that the legislature has adopted should be in terms of their criminal consequence. With that, I note that we have a whole slate of proposed amendments that were set forth for hearings. Nate tells me that it is possible to perhaps move to amend them in their entirety according to what went to the public hearing and the majority votes at the last meeting, as opposed to going through them one by one. I do note, however, that while the majority of those proposed amendments were approved by unanimous votes, there were a couple which weren't unanimous. And so before we discuss the possibility of going forward with a slate approach to the vote, I'd ask, does anyone feel that they would prefer to address either the straw man transfer, I believe that was one that was contested, and the human remains amendment, that was one that was contested. We could take those separately if people feel that it would be appropriate to have those discussions separately. I just get a sense of where people are on that. I'm not seeing anyone. Well, then I would ask if someone is willing to bring a motion to give final approval to all proposed amendments to the sentencing guidelines that were set forth in the public hearing notice dated June 17th, 2024. Is that Commissioner Reeves? Thank you. Second?
Second.
Commissioner Knudsen. Any discussion? And there being no request for discussion, Nate, would you take the roll call vote, please?
Yes, Madam Chair. To the Reeves motion to give final approval to all proposed amendments to the sentencing guidelines that were set forth in the public hearing notice dated June 17th, 2024. Larkin?
Yes.
Larkin, yes. Crutchfield?
Yes.
Crutchfield, yes. Fraze?
Yes.
Fraze, yes. Keefe? Keefe, absent. Knudsen?
Yes.
Knudsen, yes. Ladd?
Yes.
Ladd, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Moran?
Yes.
Moran, yes. Mueller?
Yes.
Mueller, yes. Reeves?
Yes.
Reeves, yes. Saxena?
Yes.
Saxena, yes. Chair Mitchell?
Yes.
Mitchell, yes. Madam Chair, there are 12 votes in favor, no votes opposed.
The motion passes once again unanimously. Thank you. We'll now hear briefly from Commissioner Knudsen regarding the Administrative Rules Subcommittee report. We were told at the last meeting the subcommittee was going to finalize its recommendations and present them for our consideration. It's done that. I'd like Commissioner Knudsen just to give a high-level overview of what these changes will accomplish in terms of our administrative process, and then we can move on to the proposal itself.
As we've discussed before, we've got a number of governing documents that control how this commission works. And foremost among them, of course, is the Minnesota statutes. But the other important set of rules comes from the Minnesota Administrative Rules, and that governs the actual procedural rules of the Minnesota Sentencing Guidelines Commission for making any changes to the sentencing guidelines. And at times we've been frustrated or concerned because of the lack of flexibility, the timelines. It made it difficult for us to respond at relatively short notice whenever the legislature completed their work, and then to get modifications or changes to the guidelines enacted as a result of new offenses or changed offenses. It also affects our calendaring for our meetings. So what we did was we went through the entire chapter 3000, which governs the Minnesota Sentencing Guidelines Commission, and looked at it, and thankfully, and that was our subcommittee, Catherine Middlebrook, myself, and Tim Warren. Great assistance from Nate and the rest of the commission staff, which had already done quite a bit of work on kind of looking at this and seeing some of the issues and problems that those rules that I believe, Nate, were adopted in 1982 at the initiation of the commission. So a lot of things have changed. So what we did was we went through, tried to be more clear, define things, and that's what I think this document accomplishes. We added some definitions. We specifically stated how we have to provide notice to the public of any proposed changes. How do we conduct the public hearings? How long is the written comment period? When can we take action following the written comment? Ensuring that the public record is available for parties. And then when is the final action of the commission effective? What do we have to consider? And again, those effective dates, but it just, and then what we tried to avoid was putting too much detail, too much specificity in these procedural rules of the Minnesota rules that would otherwise prevent us from operating in an efficient manner that really serves the public. So we think we've accomplished that. We've met about 4 times and reviewed this with Kelly as well. And what I'm asking for today is support from the commission to pursue then the modification of Rule 3000 governing the Minnesota Sentencing Guidelines through the Administrative Rules Act procedures that govern how you even change these rules, which is somewhat cumbersome as well. And that's what we also kept an eye on. Are there things that we want to be able to possibly change in the future where we don't want to have to go through this arduous process in changing our procedures? But the most important things are regarding notice, public hearings, keeping people informed, modifying how we do inform people, that we don't have to send out US mail, we can do it by email, that we don't necessarily publish our notice of any changes in the state register. It costs money to obtain the state's register. We're not sure how many people were actually notified in that process. And then because that process in and of itself is a significant delay in us getting to the public hearing and actually changing and modifying any of our guidelines. So we presented this memorandum dated July 17th, and the highlighted and underlined and redacted, or not redacted, but deleted portions of the current Rule 3000, and I think it's otherwise pretty self-explanatory. And as you can see, it's a little more understandable, so the public can understand basically what we're doing, how we're going about it, but also commission members that come on. And that was one of the things that I was struck by and was excited to be part of this, to help commission members ourselves figure out, well, what is the process? How are we supposed to do this? And use a little more plain language, a little more description, a little more specifics on the process, but then still allowing flexibility. So I don't know if Commissioner Middlebrook or Commissioner Moore want to add anything to that.
You don't have to.
No, Judge, I think you summed it up very well. Thank you.
All right, excellent. Thank you for all your work on this. It's obvious from the materials you provided for us today that it's very detailed, specific work, which is not easy to do. So we appreciate it. I think the good news for us today is that, as I understand it, we don't have to deal with all the details today. What we simply have to do is try to set your work on path to formal rulemaking. And during that process, there'll be opportunities to revise the language and wordsmith along the way. So does anyone have any questions about the work that's been done or the proposals? Any other discussion? Then I would entertain a motion to authorize staff to begin the administrative rulemaking process with a view toward amending Chapter 3000, consistent with the changes showed in the Administrative Rules Subcommittee report dated July 17, 2024.
So moved.
Second.
All right, so it looks like we have Commissioner Ladd moving and Commissioner Reeves seconding. Thank you. Could you take the roll call vote, Nate?
Yes, Madam Chair. To the Ladd motion to authorize staff to begin the administrative rulemaking process with a view toward amending Administrative Rules Chapter 3000, consistent with the changes shown in the Administrative Rules Subcommittee report dated July 17th, 2024. Larkin?
Yes.
Larkin, yes. Crutchfield?
Yes.
Crutchfield, yes. Fraze?
Yes.
Fraze, yes. Keefe? Keefe, absent. Knudsen?
Yes.
Knudsen, yes. Ladd?
Yes.
Ladd, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Moran?
Yes.
Moran, yes. Mueller?
Yes.
Mueller, yes. Reeves?
Yes.
Reeves, yes. Saxena?
Yes.
Saxena, yes. Mitchell?
Yes.
Mitchell, yes. Madam Chair, there are 12 votes in favor, no votes opposed.
Thank you. The motion passes unanimously. Thank you. Next item, fall 2024 meeting schedule. Okay, so the last one I said, good news is we don't have to do any hard work. This one changes things for us. It's my understanding that historically the commission has not met in August. So we don't have a meeting next month, but we have a lot of work to do before the end of the year in terms of receiving results of the important research that the U of M is doing for us, obtaining the information that MAD is gathering for us about public input for our comprehensive review. And we want to make sure we have enough time to digest all that information and perhaps identify some common themes and maybe rank them and try to put together somewhat of a roadmap in terms of where we go from here with this comprehensive review. So to make that work, Kelly, Nate and I met, and it's apparent to us that we're going to need more time than our normal 2.5-hour meeting. So what we'd like to do is plan on a longer meeting in September and a full day meeting in October with lunch provided. There always has to be lunch. We're going to ask you to give up a day. But our hope is that with that little bit of extra time, we'll be in a good position to go into the new year ready to tackle whatever issues we identify as being important. Questions or comments about that proposal?
What times are you talking about?
Nate, can you remind me, I think on the October, we thought either of going from 9 to 3 or 10 to 3, depending on what we think the timing might be. September, what were we thinking?
September, I think we were thinking of a 1 o'clock start still, but just lengthening it into later in the day, perhaps 4 o'clock. Or 4:30. I don't know that we have the exact times figured out, but just understand that that'll require a little bit more of your afternoon in September and October. If you could just please block out the whole day at this point, and we'll fill in the details later on.
Commissioner Reeves?
For which month? The whole day, October?
October, the whole day.
Yeah, so September 12th will be the longer afternoon, and October 10th will be the full day, please.
Commissioner Middlebrook?
Thank you, Madam Chair. I'm just curious about the Supreme Court argument calendar. Maybe Justice Moore knows that's for the full days where I'm talking about, but there may be, don't know yet.
We talked about Thursday, the 10th of October.
Yes.
Yeah, there would not be an argument that day. We have a court meeting that morning. Hopefully that's done by noon. So there shouldn't be an argument issue there. Usually the second week of the month, we're Monday through Wednesday.
All right. Chair Mitchell, anything on that? We're good. Okay then, mark your calendars. And I've asked Nate to ensure that we have good lunches in October. Now, I'm pleased because Nate said he was optimistic. How are we doing that? Got it?
Yeah. Having,
All
Sorry
set?
about that. Yep. I
No
think-
worries. I think I was about to jinx us by saying Nate said he was optimistic that we could get to agenda item number 8 by 1:30, and we have succeeded. Now it is time for the much anticipated presentation by Professor Grace. I think we were supposed to do this last time, and we've carried it over to today. He's going to talk with us to provide an overview of prominent criminal history issues and solutions. I know that he did this, I think, once before, a couple of years ago, and it was a great presentation, so I'm anxious to hear more on the topic today, as we all are. And we'll just have you present from your seat there. And is Nate going to give you a computer to work from?
All right, so I'm going to test this before I start. You thought that the forward and back, okay, that works that way, and that works that way, all right. Well, thanks for the opportunity to present to you. I've spoken at least once before I hear about these issues, and it's something I've been working on a lot in the last 20 plus years, and drove a lot of other people. So I guess the idea is there's been a lot of new research and thinking on these issues in recent years, finally, and I'm just going to try to hit the highlights today. I think based on paging through these several times at home, I think I ought to be able to get through what I'm going to say in less than 45 minutes. But I guess we have to decide whether, I don't really have a preference. Are we going to take questions and comments as I go along, or at the end?
Speaker's choice,
Oh.
I would say.
I guess what I would suggest then is that, I mean, if there's a need for clarification in something I've just said, then obviously that has got to be taken care of. Or if it's something that is just so specific to this point that really it would be kind of getting our heads back into something later on, then raise it now. Broader questions and comments maybe should be at the end. So that way, I mean, I do want to be sure I do get through, and this is a rich topic. We could all be talking about this all day. So I do want to get through the slides. So anyway, we'll just kind of try to have a balance like that. So anyway, the thing about this subject is that prior record criminal sentencing enhancements are a universal feature of sentencing in all systems, or at least all systems in developed legal regimes that have been studied with or without guidelines. But in a sense, it's so obvious a sentencing factor that it doesn't need to be debated or considered. It's just sort of, oh, everybody knows. And clearly, with a few outlying philosophical views, it is going to continue to be an important factor. But the devil's in the details. So some of the things on this slide about the formulas, they vary a lot across guideline systems. And the validity of common rationales. Why are we enhancing these sentences, and by how much? What are we hoping to achieve? What principles are being applied? Are we doing enough? Are we doing too much? And even if the rationales make sense, what about the costs and negative consequences? Any good thing is likely to have some negative consequences. So anyway, a project I directed at the Urbina Institute a few years ago examined this in detail. Some other guidelines commissions have begun looking at it and made changes. People have been writing and thinking about this a lot in recent years. So I'm, again, going to try to hit the highlights of this. And so just as an overview of the topics, we start with, well, what does it matter? How much does it matter? And has that changed over time? The rationales, as I said, there are certain premises, assumptions in each of these rationales for criminal history enhancements. And if we look at them more closely, how well do they hold up? How much enhancement do they justify? And again, things can be justified and yet have major costs and negative consequences that has to be balanced. Well, how do we balance all those things? Well, I suggested some possible solutions. Some of them are things that other guideline systems have already done. Some of them recently. Some of them I'm happy to say in response to our work or the work of other scholars. So anyway, let's look first with how much does it matter and how has that changed over time? Well, it's a major impact and it has grown over time. And I'm going to present several ways that we can measure that impact and change over time. So one is what I call the multiplier. When you look at a grid, so I'm going to jump ahead here and then jump back. If you look at the recommended prison duration for zero criminal history and compare it to the duration for 6 or more points, there's a ratio there. It varies quite a bit depending on what severity level you're on. On average, on this grid, the multiplier is 2. On average, the recommended prison duration is twice as long for 6 or more as it is for 0. So that's one measure. And you can have, well, I should stay there for a minute. Because in the gray zone, these are recommended stayed sentences. Perhaps it's misleading to compare a recommended stayed sentence duration with a recommended executed duration. So another way to look at this is to say, well, in the gray zone, judges have discretion in most cases to give anywhere from 0 to 12 months in prison as a condition of probation. If you view that as a range, a guidelines range, then the middle of that range is 6 months. So if you use 6 months for those gray zero history things instead of the recommended suspended or stayed sentence, then you get a different ratio, and it's a higher ratio. It's 4.7. So anyway, by the way, the ratio of 2 overall for that grid is by no means the highest ratio across guideline systems. There are some that have even higher, much higher, especially for certain lines on their grids. It can be, in one case, 100 times more severe for the highest criminal history. So we're kind of in the middle of the pack on that subject. Okay, well, there's some other measures of impact and change over time. So there's what I call the pushed into prison effect. This has to do with disposition. Are you recommended for a stayed or an executed prison sentence? And again, if I flip ahead here to the grid, There is what I call Zone 2, the orange zone, where it's medium to low severity offense, conviction offense, but because of the offender's criminal history, they're pushed across the disposition line into the recommended executed prison area, the orange cells there. So anyway, how many people are out there? In 2019, the most recent year that I have data for, 22% of offenders, and that's including all three grids, fell into Zone 2 of their respective grid. Whereas in the pre-guidelines year, the only year for which we have good data on for the guidelines, 1978, only 5% of offenders fell into Zone 2. So a lot more
Can
people
I
are out
ask
there.
a question about that?
Sure.
What do you mean before the guidelines? What zones were there? Or how
Well,
is that a
if
zone?
you put the conviction offenses onto what became the Minnesota grid, they would have been in what I'm calling Zone 2. And in a way, the reason I look at it that way, or I look at, what was it in 1978 is, this is what the original commission was looking at. This was their best guess of what the impact of the guidelines would be. There will be 5% of offenders in that pushed into prison zone. And initially, I think it was not too different from that, but because criminal history scores steadily rose over time, more and more offenders were out there. So anyway, that's one measure. We go from 5% to 22% in that pushed into prison Zone 2, which also, of course, any increase in criminal history for any, but anywhere on any of the grids increases the recommended sentence severity. So that's one measure, primarily focusing on disposition. And then here's two more measures, so third and fourth measures. We can ask how many offenders have high criminal history scores, and I define that as 4 or more criminal history points, and we're up to 29% of offenders now are in that highest criminal history category. Again, if you look at what the original commission would have expected will happen under the new guidelines based on 78 data, 7%. So when you have the average criminal history score going up, and especially the number of people with high scores, you're going to have more people in Zone 2. You're going to have more people with lengthy recommended prison sentences. It's just being built up. And I think, one of the issues that I think the Urbina researchers identified earlier on is, well, what are the factors that have caused criminal history scores to rise? And I'm not going to get into that today. There's a number of possibilities. But it's happened, and therefore a bigger impact on disposition over time. And another way, finally, of looking at this is, well, what about the people that aren't getting any criminal history enhancement? They have a 0 criminal history score. How many of them are there now? Only 28%, whereas again, in that baseline year of 78, 59%. So fewer and fewer 0 criminal history offenders, more and more high criminal history score offenders over time. And the commission made a big change in 1989 when they adopted felony weighting, and especially the down weighting feature of that to go to half point for low severity offenses, because they saw what was happening to prison populations with the rising criminal history scores. And that temporarily lowered the average criminal history score of offenders, but it didn't last long. And now I don't have a slide on that, but I'm pretty sure in the most recent years, the average number of criminal history points is considerably higher than it was in 1989. It just kept going up. So anyway, that's the impact now and over time.
Can I ask a question before you go on? I'm fascinated by the 28% versus 59%. Any idea what that means? I mean, as a layperson looking at that, to me, it says that means fewer people are committing crimes, but a smaller group is committing all of the crimes or more of the crimes. Is that a fair interpretation?
Well, there's certainly, I don't know, one theory of all of this is there are more chronic offenders as a proportion of all the offenders. And I guess another question, we're probably finding more prior convictions, or databases are better. There may be changes in prosecutor charging and plea bargaining practices that, combined with the Hernandez rule, increase the number of people with higher criminal history scores. And I don't know, I mean, there are other reasons. I think it's been mentioned that while offenders are on average older at the time of sentencing, they've had more time to accumulate higher criminal history scores or to have at least 1 point. So yeah, there's just a lot of potential reasons there, some of which we can't do anything about or might not want to do anything about. Others are things that are kind of, well, okay, yeah, the conditions have changed, but here's the bottom line of what we have with all these high scores now. So anyway, it's something to think about anyway. So the rationales, I identified 3 here for why, he's already been punished for the prior crime. Why are we in a sense punishing him again? Because he has a prior conviction, whereas this other offender doesn't have that prior conviction. So for just deserts retribution, the assumption has to be that that repeat offenders are more blameworthy, more culpable, and they deserve more punishment, and that they deserve it in proportion to the number and seriousness of their prior convictions. And I'll come back to each of these things. In crime control, we have actually 2 assumptions. One might think it's only one, but the first one says, are repeat offenders more likely to keep committing crimes? Are there higher risk of recidivism? And is that in direct proportion to their prior records? There's more research on that now than there ever was before. But equally important is, and this isn't just an issue for prior record enhancements, does giving repeat offenders more severe punishment in proportion to their prior records, does that prevent crime in a cost-effective manner? Surely it prevents some crimes, no doubt about that. But we have to consider resources and best use of resources. So finally, I add in public opinion here because it's something we do take into consideration. We want criminal justice needs the support of the public. So the assumption here, I think, is that the public strongly supports these enhancements, including the way we're doing it now. So I'll look at each of these things. So retribution, are crimes by offenders more blameworthy? And why is that, and how much? So as I alluded to earlier on, there are some retributive theorists, people who think that retribution is the most important, if not the only reason for punishment. And some of them say that you shouldn't consider prior convictions at all for a couple of reasons. Well, first of all, they don't increase an offender's deserved punishment for a new crime. How do we measure that? We measure the desert of the new crime based on the harm that crime causes or their risks, and the offender's culpability, things like mens rea, motive, role in the offense. So if you look at those key elements of desert and deserved punishment, how does a prior conviction increase that? Well, people can have debated that. But the other issue I alluded to earlier is that you have to have a theory that says that the offender is more culpable for this new crime because of his prior crimes. You can't just say, well, he's more culpable in an overall sense because of the prior crimes, or we didn't punish him enough before, so we're going to give him more of his deserved punishment now. Because that essentially violates double jeopardy rules. Somebody's been punished once for a crime. Under double jeopardy rules, they can't be given new additional punishment for that old crime. We have to say that the new crime is more culpable because of and in proportion to the prior conviction record. So, I mean, that's a minority view among retributivists. Most writers say, no, prior record should be considered to some extent, and then, well, to what extent and under what principles would we define and limit those enhancements? Well, there's broad consensus on that first offenders are less blameworthy. Some people say very significantly less blameworthy. They've obeyed the law up to now. Give them credit for that. Maybe this was kind of a situational thing and not some sort of character flaw, and we at least ought to give them the benefit of the doubt. So there's an agreement on that. There is agreement that after that point, we're talking about second offenders, second, third, fourth, that desert increases, but only modestly with rising criminal record. And related to that you have to keep the seriousness of the new offense in mind. And the desert depends more on that than on prior record. And that has two implications. One, that you have to cap the criminal history enhancements, and virtually all guideline systems do that. You know, as your criminal history score, your number of prior convictions rises. At some point, there's no more criminal history enhancement. We say, okay, that's as much as we can enhance for criminal history. Otherwise, you end up with somebody who just keeps writing bad checks being publicly punished like he was a murderer. The second reason is that, a related point is that, you know, we want the, at least this theory says, retributive theory says, we want the current offense to be the primary driver of punishment severity. Prior record shouldn't have more weight than that. So a doubling rule basically says, well, they're even. If you max out at the capped criminal history, you get twice the recommended sentence as the no criminal history first offender. And that means that the crime you're being sentenced for and the criminal history are given equal weight. If you go more than doubling, then the criminal history is actually getting more weight than the current offense. Some writers would say not even double, but at least no more than double. So anyway, those are, you know, retributive perspectives on this. And I guess my theory, and I think it's pretty widely shared among theorists, but certainly not universally, is that between desert and crime control, well, they're both important. And they're both limiting in the sense that you can't punish somebody more than they deserve. It's unfair. And you shouldn't punish people more than is useful for crime control purposes, because that's kind of wasteful. So it's kind of deserved and cost effectively useful. So let's look at crime control. And it focuses on risk of recidivism. And is that proportionate to prior record? Well, that breaks down into at least three different sub-questions, which have now been studied more than they ever were before about 10 years ago. Does the criminal history score overall accurately predict recidivism risk? Secondly, does each component of the score add predictive value? Because you could have a score that is fairly accurate, but it's including elements that don't add any predictive value. All they do is add cost and punishment severity. And finally, what kinds of recidivism does a higher criminal history score predict? Because if it predicts writing bad checks, that's different from predicting armed robbery or murder. So what kinds of recidivism? So anyway, these really fundamental questions hadn't been addressed until recently. Again, I said at the outset that prior record enhancements are just such an obvious, intuitive reason for punishment enhancement that people thought, there's no reason to question it. Let's just see what judges have been doing in the past or what our intuitions tell us rather than collecting any data on it. But now, both in Minnesota and Pennsylvania, in the federal system, I guess to some extent in Virginia, we have data on some of these issues. So what does it show? Well, let's look at the three questions again, the questions that were in the last slide. Does the score overall accurately predict recidivism risk? Well, in Minnesota, yes, it does. There's a steady increase in recidivism risk as offenders have higher and higher criminal records. I have a bonus slide in this packet. I guess it's in the version posted online if you want to skip to that. But it's been presented to you by Julia Leskinsky and other Robina people. Pretty positive, linear, steady increase in, well, maybe not linear, a steady increase in risk of recidivism with higher criminal history. But it isn't linear. So this book, if you look at the jumps in recidivism risk as measured by reconviction rates, the biggest jumps are at the low and high end. So the jump from 0 to 1 criminal history point is the biggest single jump, I think. And then if you look at the high end, we lump together 6 or more points. But if you break that down into exactly 6 points versus 7 or more points, there's a big jump there. Not much jump, or any jump actually, between 5 points and exactly 6 points. It had leveled out by then. But when you get into even higher levels, then it jumps up again. So it's not linear. And then a couple of other major findings that qualify the overall positive correlation. If you look within the category of zero criminal there is what can be called a true first-time offender who has no known prior convictions. And you compare those people, true first-time offenders, as far as we know, to other people with zero criminal history who have one or more known priors, but they've lapsed, they aren't scored, they didn't affect the criminal history score, so they don't raise the person beyond zero criminal history. So you can compare true versus people with one or more known priors, and the trues have much lower recidivism rates. And finally, if you look at things besides criminal history score, if you look within each of the criminal history score categories, this slide I realize is a little bit poorly expressed. If you look within the criminal history zeros, within the ones, the twos, the threes, within each of those categories, recidivism decreases steadily with age. And if you look at the higher categories, within 4, within 5, within 6 or more, the oldest group, 45 or older, have the lowest or second lowest recidivism rate. So here's a major recidivism predictor that is cuts across these criminal history categories, and it's just a major variation within each of those categories, but is not formally considered by the guidelines. I don't know if judges formally consider it.
Professor?
Yeah.
With the aging population, the dropping testosterone, whatever, is it a lowering in violent crime, and are they moving to a different sort of crime, or are they not recidivating at all?
Well, I think it's both. I think it's a general matter. I'm trying to remember from the work that Julia Laskarinsky did, and maybe Kevin is here will remember this, but or Kelly will remember it. I'm not sure. I mean, the general assumption is that violent crimes, murder and robbery, probably also aggravated assault or so many of them, declines with age because it's just not as much energy, it's anger.
It's a young man's game.
The best cure for crime, especially violent crime, is getting old. But that doesn't necessarily mean they aren't committing crimes. There are certain crimes, I guess, child sex abuse probably just keeps going more than forcible rape. And there are obviously property crimes that can easily be committed without much energy. But people, life course events happen. I'll come back to that later. They just give people less of a stake or less of an interest. I'm too old for this. I'm tired of this. So, but nevertheless, the biggest change is violent.
Thank you.
So, anyway, the second question related to crime control, risk, recidivism. We look at each component of the criminal history score. Is it adding predictive power, or is it just costing us more and posing more suffering on offenders and their families? And of course, even if it does add predictive power, we have to look at the cost and negative consequences later on. So anyway, there are some, Julia Laskarinsky's work looked at this quite a bit. There are some components that add little to no predictive power. So custody status and misdemeanor add modest power, where there's this area under the curve statistic that it's got to be more than 0.5 or you're not getting any predictive power. So the score overall has a modestly good predictive power in the low to mid 60s, but it doesn't change much whether these variables are in or out. And juvenile points didn't have any predictive power, and that's partly because so few offenders have a juvenile point. And then felony weighting. I'm not sure this is in some of the reports. I don't know when it was presented. But if you say, well, let's just imagine that we didn't have felony weighting and every felony counts 1 point. What kind of predictive power does that score have? And I think that it found that it didn't really change things. It didn't make it worse, although oddly enough, it ought to make it worse because when you look at offense severity at time 1, was he offense level 7, 9, 8, 9, or was it like 1, 2, 3? And what is the risk of subsequent convictions for high severity? It's a negative correlation. The people with the convicted of low severity offenses have a higher odds of coming back again. Now, the question again, with what kind of crime, a critical question. But at least in terms of recidivism versus no recidivism, it's higher at lower severity than it is at high severity. Now, there is a caveat here that felony weighting, I think the primary reason it was thought of and adopted in 1989, I mentioned earlier that just too many property and nonviolent offenders were being recommended for prison as criminal history scores rose. So the thought was, well, let's only give those people half a point and their scores won't rise as fast, or we won't have as many of them recommended for prison. So that's an issue. That's a policy judgment that isn't related to risk prediction. It's related to prison use priority. How do we want to use our limited, expensive prison cells? And above all, avoid overcrowding of prisons. So anyway, one more issue that I mentioned before. What kinds of recidivism? I mean, you just say, yes, no. He had a new conviction, he didn't have a new conviction. Well, it matters what the new crime was. And we have some data on that too. Overall, most recidivism offenses, take all the people who get us another conviction. Overall, it's usually a property or a drug crime, like roughly 2/3 or even more of the recidivism crime or property or drug crimes. And that is true even at the high criminal history score, 5 or 6+. It's still, in fact, overall, the 5 and 6 pointers have slightly more property and drug crime recidivism crimes than at lower criminal history. So it's yes, some of the new crimes are violent crimes, but most of them aren't. So anyway, that's just to summarize. Yes, it does predict risk, but it doesn't always do that really well, and it can do it in a way that increases cost and severity without really having a measurable crime control benefit. There's components that don't add much, if any, predictive value. There is the problem that most repeat offenses are not violent crimes, so that's what we're predicting and preventing much more than violent crimes. And then there are the things that aren't counted in criminal history, most importantly, offender age. That this isn't factored in, and under the current rules, judges are not invited to consider the offender's age, or even necessarily authorized to consider the offender's age. Maybe it comes in the back door of amenability assessments, but it's just not a factor. So anyway, that's really critical issue. This is back to the question a minute ago about age and crime. The age crime curve is one of the most well-documented findings in criminological research, but it has had almost no policy impact in sentencing policy, including under guidelines.
Commissioner Middlebrook?
Thank you. I just have a question on the types of recidivism offenses. You talked about property and drug crimes. So was there any looking at were some of those in large part due to addiction or to economic situation? Was there any accounting for those? Just kind of theorizing why those.
What's driving the property and drug crimes? No, well, the data that the Rabina project had and that Julia was working on was Guidelines Commission data, so it didn't have those kind of background. But surely it's very plausible that for many people is a driving factor. But I guess there are people who just decide to, their business model is robbing or burglaring, or their business model is selling drugs. And that's what they know how to do, so they keep doing it. We have to consider, even if, and to the extent and when prior record enhancements correlate well with risk prediction and recidivism prevention, is this being done in a cost-effective way? What are we getting value for money here? What is the cost benefit in a sense? So anyway, this is just a summary of a whole lot of research, almost none of it done by me, but I'm a consumer of that research. And if you break it down into the crime control justifications, the most important ones being these 4, the critique of the application of that justification to prior record enhancements, again, based on research, it doesn't seem, I'm just going to summarize this very overall, but I certainly answer the question. For each of these things, there's not a very strong argument for prior record enhancement, especially for major prior record enhancements. Prisons don't rehabilitate as all that well. Specific deterrence, it cuts both ways because some people do get worse in prison and do not learn their lesson, hang out with the wrong people. General deterrence, there's lots of research on this now, lots of different consequences, findings, contexts. If you take, in the United States, sentences in a world perspective are relatively severe, and at least in that context, but I think this research is international now. You increase a penalty, it's very hard to find that increase has had a general deterrent effect on crime for all kinds of reasons. Increasing the certainty of punishment seems to have a more measurable effect because most offenders don't expect to get caught. But if we can make that threat a little more credible, it seems that can be valuable. That costs money, money that we might want to not spend so much elsewhere. And incapacitation, again, some offenders get worse or are replaced by other offenders. Or they're just going to get less crime prone as they age and long before the expiration of their enhanced term. So anyway, it's easy to overstate the crime control value under each of these rationales, which is not to say there's none, at least for the last three. But it's hard to find a substantial crime control benefit, at least based on all the research that's been done. Finally, public opinion. We have to take that into consideration. Whether they're right or wrong, but especially if they might be right. So, what does the public think about existing criminal history enhancements? There's not a lot of research on that, and some of it has been done by at Rabina and also by Julian Roberts, who's at Oxford University, sort of the world expert on public opinion and criminal justice. And there is support for such enhancements in general. Again, it's an intuitive thing. We all kind of think, prior, recidivists should be punished more severely. But when you get down to the details and the components of this kind of a policy, one question that was asked was, you asked people, members of the public, how far back should we look? When should we no longer count a prior conviction? And the public, some of them said less than 10 years, but there was little support for anything more than 10 years as a look back period. And similarly, or more so, you ask the public, should we, sentence this person. Now imagine this person has a prior juvenile adjudication. Does that change your view? And generally the public said no, which seems to be saying that, why do we have, there isn't a lot of follow-up with this to debrief people about, why not? But that was what they said. So anyway, those are sort of the rationales. And then even if you have rationales, one or more rationales that are valid, at least frequently to a great extent, we have to consider the trade-offs. And so here's just a summary slide of things that nothing's free, and lots of good things have negative consequences. We may have to do them anyway if necessary to do them, but we do want to weigh the consequences, try to minimize the consequences. So anyway, I'll go through each of these quickly. How am I doing? When do I lose the judges? 3?
Yeah, hard stop at 3.
Yeah, okay.
Sooner before. Yeah.
Okay. I'm going to make that.
Yeah.
I'm up to slide 20. All right. So, obviously, the more people you recommend for prison, the longer recommended prison sentences. If judges are following the guidelines, which they do mostly, with notable exceptions, then you're going to get larger prison populations. And that's going to include a lot of people who are convicted of medium or severe crimes who would would otherwise have non-prison sentences. And that those people, Zone 2 people, have grown substantially. They now, in the most recent year that I looked at, just adding up the 3 grids, the number of people in Zone 2 on the 3 grids, comparing it to the total number of offenders that year, 2019 it must have been, data. About 2/3 of all the cases recommended for executed prison are coming from Zone 2, not from high severity conviction offense, not from mandatory minimums for lower criminal history people. So it's again it's a major impact. Again, that's Zone 2, just to remind us of what that means. And I'm, by the way, I'm looking at this, so somebody else will have to recognize questions, because otherwise I'm going to miss them. So, anyway. All right, so proportionality. That's again, it's a bit like prior record enhancements. Everybody's in favor of proportionality. People define it differently. The details matter. But as a general principle, there's broad consensus that, and this is true both from a retributive justice search perspective and from a crime control practical perspective. We need sentences to be at least roughly proportional to the seriousness of the offenses being sentenced, conviction offenses. But under the guidelines, there are some major overlaps in recommended duration and recommended disposition. So if you look at, I shouldn't have skipped ahead quite so much. The first example has to do with disposition. So on the grid, I will just come back to in a minute. If you look at the disposition line, how that relates to severity level, I mean, this is obvious. It's been there since the beginning, and yet we don't want to think about the lack of proportionality when somebody with the lowest severity crime is recommended for prison, whereas all these people going up to level 7 are not recommended for prison. I'm not as troubled by that, because after all, it's suspended prison. They may end up in prison. But the duration thing is more troubling to me. The idea that somebody, again, that severity level, high criminal history, 19 months recommended sentence, executed sentence. You just look at the number, not whether it's stayed or executed. You have to go up to level 6 before you get people recommended for a longer sentence. So all those people in the first box on 5, and all more boxes below that who are higher severity, more culpable, more deserving of punishment, more need to have proportionality for practical reasons. They're recommended for shorter sentences. So there's a substantial overlap between the end of one row and the beginning of the next row. Sometimes the overlap goes for several cells into the higher row. So that undercuts sentencing proportionality relative to conviction offense. Again, it's a balance. You can't have it all. You've got to try to balance. Okay, third consequence here. I've alluded this before, that do we want to have that many prison beds used for property and other nonviolent offenders? We don't want prison overcrowding. Do we want to build more prisons so we can house those property and nonviolent offenders? And Minnesota isn't the only guideline system that's chosen to give prison priority to high severity and violent offenders. But it's the lower severity and nonviolent offenders who tend to have higher criminal history scores. So again, the bigger your prior record enhancement, the more frequently it applies, the more it's going to change that prison priority or undercut that prison priority policy. And again, that's why the commission in 1989 went to the half-point weighting to try to cut back on that overuse of prison. So anyway, if you look at so the 2 examples here, fingers twitching and I'm advancing faster than I mean to. First example, Zone 2 again. About 2/3 of them have been convicted of a non-person offense. Now, a non-person, it's a term we use in the guidelines. is roughly comparable to violent, nonviolent, but it's not exactly the same. But it's the one we have always used in making policy judgments, in particular about how to use prison cells. And out there in Zone 2, 2/3 of them are non-person offenders. And the second example here, if you look at, the people with the highest criminal history categories, that's 5 points or 6 or more than half of them have just been convicted of a property or a drug crime, most often not of a person offense. So those property and non-person offenders are disproportionately getting, most frequently getting the highest priority enhancements, going to prison for longer. Fourth consequence, increased numbers of aging, geriatric, near and dear to my heart, low risk, high cost prison inmates. So, we have look-back limits. They're not as strict as some systems, and seemingly not as much as the public support. So that means that even with those, a lot of older offenders are gonna come to sentencing with a high criminal history score. And yet, as I said before, they tend to have lower, sometimes much lower recidivism rates from that point on, because they're aging out of crime or almost have already. And because of their medical costs, they can be very expensive. But nevertheless, a lot of them are going there and going there for longer, and so the numbers build up. I don't have it in front of me, but I'm pretty sure that the proportion of Minnesota prison inmates who are 50 years and older has steadily gone up. I don't know what that number is now, but they build up there. So fifth, racial disproportionality, something this commission has always been concerned about and looks at now with demographic impact assessments. And it is, given relationships between race and poverty and crime, and to some extent, the way the criminal justice system processes people, African American and Native American offenders do tend to have consistently higher criminal history scores. So there's a disparate impact, not an intended impact, but a disparate impact on those ethnic groups. And it's a major contributor. In fact, the most important contributor that I've been able to identify. It is true that some of these offenders are overrepresented in every part of the guidelines grids, but it's their overrepresentation in Zone 2 in particular that accounts for like 2/3 of their overrepresentation in prison. It's a major contributing factor, more important than high crime severity, more important than mandatory minimums. Finally, we all hope that offenders when they get out of prison will reintegrate into society, or if they're not going to prison, that they can stay straight and desist. But desistance from crime is a little bit like abstinence from chemical dependency. It's kind of a relapsing phenomenon where we measure progress by longer and longer periods of desistance, rather than all at once cessation of criminality. And some offenders are making significant efforts. They're trying. They're keeping a job, staying, supporting their family, getting treatment, but they may still lapse. And so, do we want to interfere with what may be generally progress in rebuilding a career, holding a job, supporting family, and having a place to live? A prison record doesn't help any of those things. And the longer it is, the more potentially damaging it is. Now, interestingly enough to me anyway, in light of the first paragraph there, no guideline system seems to give any formal credit for an offender's good faith, unsuccessful efforts toward desistance. Nor does any system take account of trends. So, the fact that this person's coming, he's offended again. His new crime is less serious than his old crimes. He's going in the right direction, but there's no way formal account given to that. There is in several systems, however, formal recognition of the significance of a crime-free gap. So even though this prior conviction is not 10 years old or 15 years old or whatever your look back is, this guy has just gone 5 years without a new conviction, which for him is progress. And so some systems have a recognition of crime-free gaps, independent of the issue of look back. You say, okay, you're going in the right direction. You're not there yet. Anyway, what are some possible solutions? And this is just a very preliminary list, based on largely on the research that I just policy thinking I just summarized. And again, a consistent theme here is we've got so many high criminal history score offenders, rising over time, much more than under the original guidelines. If we can reduce the number, a proportion of those offenders, then most of the cost and other bad consequences will be reduced. So how do we do that? Well, obviously you're going to have shorter look-back periods, so we don't. There are still a few guideline systems that have no look-back limits. So a conviction lasts the person's entire lifetime. Something you did when you were 18 counts against you when you're 55. We don't do that, but we do go back quite a ways. The Hernandez rule is almost unique in guideline systems. The idea that when somebody is sentenced on one day, their criminal history score rises as each new crime is punished. Oops, I don't want to go yet. So he's 0, okay, sentence him for that crime. Okay, now he's 1 or maybe 2. Sentence him for that. Okay, now he's 3. And you skate across the grid in one hearing under that rule. Only, I think Washington State has a rule like that. I don't think any other state does. And it increases the number of people with high criminal history scores. They get high in one day. Well, the research I mentioned before, there are elements of the score that have low predictive, had low or no predictive value. And upweighting, as I said, doesn't because of the negative correlation between offense severity and future recidivism. Limiting eligibility. Here's something several other guidelines commission systems do. How can you get out into the high criminal history category recommended for executed prison, longer prison sentences? Well, several jurisdictions say you can't just get out there with nothing but property crimes. Because even with down weighting of property, low severity crimes, people can still end up way out there in high criminal history categories just by having a whole large number of those. So these jurisdictions say, our prisons are primarily for dangerous people, for people we're afraid of, just cannot be left in the community. If you haven't, either this crime or some prior crime is not a person offense, or at least a high enough severity offense, you just can't get higher than a certain criminal history score. So that's another policy option some states have used. Oops, did I? Okay, I thought there was one more on that, but I don't see it. Okay, something. Oh, sorry.
Similar?
Yeah, that one. So back to the retributive rationale, I've been most persuaded, because retributive scholars, people who study and advocate and think hard about just desert sentencing, have made heroic efforts to say why the new crime is more culpable because of the prior crimes. Well, I think one of the strongest arguments is the idea, if this new crime is the same or similar than the one you were previously convicted of, punished of, censured for, don't do this again. You went and did it again. That to me, intuitively, is the strongest retributive case for enhancement. Whereas, if the guy has just written a bad check and 5 years ago committed an assault, I guess that just desert argument just doesn't seem as convincing to me. So that would be another way to limit the number of people with higher criminal history scores. Now, there are other ideas that don't really have anything to do with that general policy of limiting high criminal history scores. So I mentioned the problem of proportionality. So if you reduce sentencing level overlaps, that would probably tend to reduce the size of it could reduce the number of people with high criminal history scores and the impact of criminal history, depending on how you do it. Now, the research I mentioned before, it doesn't show a linear increase in risk as you go across the middle categories of criminal history. It's kind of pretty modest in the middle region there. It's highest at the lowest from 0 to 1, tying in from 5, from exactly 6 to 7 or more. In the middle, there's not much change. That's been found in other guidelines jurisdictions too. So one could collapse some of those categories and somewhat shrink the range of recommended sentences on each guideline severity level. I keep hitting the wrong button, sorry. Washington State has an interesting policy called the first offender waiver. It doesn't apply to violent offenses, I think, and there are limitations on it. But again, it recognizes both the retributive and the risk-based rationale for saying first offenders, people with at least no scored prior crimes, especially people with no known prior crimes, that they should have significant mitigation. And I've argued, and most recently, that maybe second offenders are really the baseline. Most offenders now come in with at least one prior conviction. So you can't say that first-timers are the real baseline and the normal case. They're not normal anymore. So if you start with sort of a baseline of a second offender, then the idea would be to have a lower drop going down to zero criminal history than we have now. Right now, it's in terms of the grid itself, the progression from 0, 1, 2, 3, 4, 5, 6 plus it's that progression in terms of recommended prison sentences is linear. The risk increase is not linear, and the retributive differences, at least at the lowest end, are not linear. So that would be one way to reduce criminal history impact, or at least recognize another factor in criminal history. I said before that it may be difficult to give an offender credit for their efforts to desist, but sometimes I think if judges can look at various amenability factors, they could look at this as part of that. I'm not sure that they do, but we could be good to incentivize and reward offenders for trying, even though they relapsed. Trends, as I mentioned, we do not recognize that at all. If they're going in the right direction, gaps, as some other jurisdictions do, and age. Again, no way to formally recognize that under existing rules. And then finally, and this to me is a real anomaly in all guidelines systems, almost all guideline systems. We allowed all sentencing judges to recognize atypical offense factors. This offense is more culpable, more serious than the typical crime of this nature, or it's less. And so you can increase, you can depart, and those departures for atypical offense severity are, I think, under Minnesota law, almost always focused on duration, not disposition. So we invite judges to make those adjustments based on conviction offense, and they do it often. But we don't invite them to consider whether there's something about the offender's prior record and or his life course situation that makes his case atypical. And in particular, it makes the criminal history score over-predict his risk. Now, sometimes it will under-predict his risk. It can be a two-way street, although there are more legal issues involved in enhancing based on facts like that. But so the life course changes. It's I think, as part of criminal careers research, life course research. We know that getting married or being in a long-term relationship, becoming a parent, achieving stable housing and or employment, getting treated for the thing that caused you to commit crimes before. There is no formal recognition that these prior convictions were related to something he's been treated for now. And all the better if he sought the treatment, if he's agreed to stay with it, work with it. So we don't adjust the criminal history score or in any other way formally take into account those life course changes, except sort of perhaps indirectly through amenability case law. So anyway, there would be things that could be done there. So that, I guess, is all I have. I'll leave it with the last substantive slide. There are bonus slides here, but I don't think I need to go into them. What do I do? All right.
You did great. Thank you.
Did I
That's a
talk to
lot of information.
Yeah,
Thank you.
and I tend to talk too fast out with it.
No, you did a great job. You covered a lot. You've given us a lot to think about. I made a whole page of notes about, well, here are some things we could maybe talk about in terms of adjusting criminal history scores and bed counts and all these things. Does anybody have any questions they want to ask at this point? Obviously, this is not the first and last. We're going to hear of these topics, these things, these ideas. They're the very things we're going to need to dive into as we look at the guidelines going forward and into much more depth once we decide what our priorities are. So I don't want people to think if there aren't questions today, this is the last we're discussing the topic. This is just an overview to get us thinking about the future. Anyone? And I don't see anything online. Well, then thank you very much. It's a lot of work. We appreciate you doing it for us.
It was an update. I haven't done the version.
It's still a lot of work.
You want to?
Hold that. There you go.
Thank you very much.
Okay.
You need this back?
I'll get it later, that's fine. Thanks, Richard.
Okay. Well, now we'll turn it over to Nate for the Executive Director's report.
Thank you, Madam Chair. Just a couple of things from me. The 2024 NASC Conference, National Association of Sentencing Commissions, will be held in Raleigh, North Carolina in less than 2 weeks. So a number of commission members and staff have been invited to go to that. The other thing is, based on your decision earlier in the meeting, we will be publishing.
Retribution.
We will be publishing an updated edition of the 2024 updated edition on August 1st of the sentencing guidelines. So that's all I have for my report, Madam Chair.
That is all you have. Then that brings us to public input. Do we have anyone on the line who wants to make comments today?
So members of the public, if you would want to make a comment, looks like everybody's on a computer, so you should be able to press a button there to raise your hand. So go ahead and do that at this time. I'll give you just a minute to do that. Not seeing any hands raised. Madam Chair, while we're waiting for that, I do want to call the Commission's attention to the fact that there was one written comment that was not pertinent to the public hearing, but it was nevertheless a written comment that the Commission does receive from time to time, and that is included in your meeting materials. Madam Chair, it does not appear that any of the members of the public who are online wish to make a public comment based on the fact that nobody has raised their hand.
Let me ask, does Chair Mitchell have anything she'd like to share with the Commission today? Thank you. Well, then I would take a motion to adjourn. I don't know that that's ever happened in the history of this commission at 2:25. Who wants to be the celebrity? So moved by Commissioner Ladd, second by Justice Moore, and with that, we are adjourned. Thank you.
This is like occasionally you teach.